Hello everyone. So I just woke up a few minutes ago. I decided I would do straight law for the midterm, and I would divide the video in two because it's so long, and I'm not gonna finish on time if I just do one video. Just bear with me if I talk too fast or anything. What is law? Laws is the regulations and rules made by the government to regulate the conduct of the people. What is the difference between laws and values? So laws promote values such as our human rights, fairness, and the resolution of conflicts. We value many things as a society, such as truth and honesty. However, not everything that is moral is illegal, and you should know that for our exam. One example is from the lenses of a Catholic. Abortion is technically immoral for someone who's a Catholic, but it is not illegal, however, so there you go. What are some types of laws? We have criminal and civil laws. So for criminal laws, this is where the government prosecutes, and it includes both felonies and misdemeanors. We'll get into that later. Civil, this involves private individuals, just know that. So for a criminal, the plaintiff or the person who brings the case is the prosecutor or the government. The defendant is the accused, and the guilt will be based upon beyond a reasonable doubt. Now for civil, the plaintiff is whoever brings the suit, and then the defendant will be the accused, and the guilt will be based on the preponderance of evidence. That is the evidence of the plaintiff who brings the case. What are the 6 principles of the Constitution? So we have limited government, which is meaning that the government cannot enforce whatever they want. They must follow the Constitution. We have separate powers, which is meaning that there are 3 distinct branches that all enforce different laws. Then we also have checks and balances, which is pretty much saying that the branches must be in agreement and check on one another. Then you have popular sovereignty, which is essentially saying that the power ultimately comes from the people, and it is them who rule it. Then you have judicial review, which is reviewing legislation to determine if something is constitutional or not. And then you have federalism, which is simply the dual nature of our government. That is, the government is based on federal and state. Then we have who makes laws, and we have a few types of people or things that make laws. So we have Congress. When they are passed, they are called statutes. States, they can also pass statutes. Local governments, their laws are called ordinances. Maybe I mispronounced that, but it's okay. You get the gist of it. Then we have agencies, such as the Environment Protection Agency, for instance, which can protect us from pollution and establish laws regarding this. And you also have courts. So these are called presidents of courts, whereby courts can establish laws by reviewing cases. So this is what happened with Plessy versus Ferguson and Brown versus Ford when it was overturned. So if a court deems a law, they establish a precedent. That's the point. Just know that courts can do that, and they have the power to do that. What is Supreme Clause? This is simply stating that the Constitution is the supreme law of the land. What are treaties and how they're handled? They're handled by the president, and they include nations outside of the U.S. Some treaties that were made include the NAFTA, or the North American Free Trade Agreement, the Treaty of Paris, which you know from the Revolutionary War. I don't know if you know more than that, but you know. What is lobbying? Lobbyists pressure Congress members into their positions. They donate money to their cause to influence their vote on legislation. These are people who are pretty much living to promote the congressman to vote for a particular cause. What are 2 ways of lobbying? So we have professional lobbying, which includes groups such as the NRA, because they are trying to always influence legislators through money. You also have grassroots, which are simply ordinary people that are less formal. They are participating in rallies and letter writing campaigns, and they have less money and do not staff. They don't know legislators personally. We also have what are the due process of voting. So if an initiative which involves the petition, then you also have the referendum, which is simply the actual act of voting. So doesn't get those too confused. What does it mean to recall someone? It means to remove them from office. What is the name of the agency that limit how much people can donate to campaigns for lobbyists? So this is called the Federal Election Commission, and it exists to even things out. What is negotiation? So this involves 2 people in conflict. It is less formal and constitutes of preparation, negotiation, and post-negotiation. There are 3 phases. An example of it could be that maybe an argument over who gets the bigger room in a new home. So these are things that are not too serious, and it only involves 2 parties. Then we move on to what's called mediation. Mediation, you are involving a third party. However, it's pretty much the mediator sets up the ground rules. Each tells his side. Mediator helps each side understand mediator, etc. So pretty much you have a third party. However, it's not as serious. It is serious, but it's not so serious as the next one we're about to talk about. So an example could be divorce on how to separate property. So they have a third person trying to help them out. making a list of solutions and making identify a better solution. Then you have arbitration, which is where disputants agree to have one or more to make a decision. They tell their side the decision is binding and must be followed. So an example could be going to court for an issue such as custody for somebody, perhaps, but there's a third party or more involved, always. So just an arbitration is a more serious one. What are the general steps for all of these? So we have to define the problem, state the issue. Each side speaks. Listen and ask clarifying questions, identify a solution, agree, tell whomever, and come up with a resolving plan in case things don't come out as planned. Then you have what are the types of trial courts? So it could be either civil, criminal, juvenile, or traffic. What are the types of appeals courts? So we have both federal and state appeals courts. These are the appeal courts are the ones that review cases from trial courts, and it's generally as high as you can go. People don't generally go up to the Supreme Court, which is the next one, though you can definitely, but they will not always pick every case. So Supreme Courts are cases. These are based on constitutional issues. Sometimes they may go to national U.S. Supreme Courts, and some states have Supreme Courts. Know that. They pick the most key cases to review here. Some examples include Gideon versus Wainwright, Miranda versus Arizona. So if you're not familiar with Miranda versus Arizona, what happened is this was a Supreme Court case that overturned Ernesto Miranda's conviction for kidnapping and rape, simply because he had not been informed of his legal rights prior to confessing. So he did not know that he could ask for an attorney or remain silent during questioning. So violating Amendment 5, which is protection against self-incrimination, and the 6th Amendment, which is the right to an attorney. What are some of the roles of lawyers? So lawyers are not free for every dispute. You don't ever want to defend yourself. Some lawyers can take contingency fees. So contingency fees means, for instance, that if you win, you get they get 30% of the money. That's one. Some other may just have a flat fee, so it depends on the lawyers. But the lawyers are pretty self-explanatory what they are. Then you have where can you find the lawyers? So in the business book, commonly known as the law directory. However, the best way to know one is word to mouth. What is an attorney-client privilege? This states that lawyers cannot state what you have told them in confidence. Attorneys cannot tell courts, everyone entitled to a defense. Jury determines the decision and punishment. So what's the process for selecting a juror? It's just called voir dire. Maybe I mispronounced that. It's from the French, coming from to speak the truth. This is like a screening process where opposing lawyers, they start asking questions to the jurors to ensure as favorable as fair jury as possible. Jury to ensure it's favorable. So they ask questions to see who is impartial, what is removal for cause? Essentially, it's saying, I don't think you're a good juror because you're not fair and impartial. Peremptory challenges are simply the same thing, but you don't have to give a cause for removing a juror. These are just two ways that you can remove someone if you simply don't like them. What are the two types of crimes? So we have state crimes and federal crimes. What's an example of a federal crime? So that could be maybe killing the president or even racketeering since you're crossing boundaries. What is mens rea? So mens rea is sort of like the concept or the intention or knowledge of wrongdoing in a crime. Just simply that you're aware of it. What are two classes of crimes? So you have misdemeanors, which is normally minor and generally less than a year, and you have felonies, which are serious and generally way more than a year. Who are the parties in crime and what are the roles? So you have, when committing a crime, you have the principal, who is the person who commits the crime, and you have an accomplice, who is the one who aids or assists the principal. So what are the two types of accomplices? So you have accessory before the fact, which is saying that, meaning someone is not there when the crime is committed, but they may have helped. And the accessory after the fact is someone who assists the principal after they've committed the crime. He may be held liable for justice, and both could be. What are crimes of omission? Simply failing to give something, such as tax evasion. So a crime of evasion could be simply not paying your taxes. What are the preliminary crimes? So you have solicitation, which is selling something, asking to buy something, solicit someone to do a crime. Then you have attempt, which is you did all the planning and execution, but it did not occur. But it is nevertheless a plan. And then you have conspiracy, which is more than just one person being involved. What is the standard of proof? So this is simply, standard of proof just says what the jury says, what they're going to weigh, which is either beyond a reasonable doubt for criminal cases, or the preponderance for evidence for civil cases. What is homicide? This entails killing someone in malice intent. What are the three types of homicides? You have felony murders, first-degree murder, second-degree murder, manslaughter. Remember that first-degree murder is premeditated, second-degree murder, there's malice, but there's no intention. For first-degree, there is intention, and so forth. What are the three types of manslaughter? So you have voluntary, which is there's an intention or plan, involuntary, which happens accidentally at the moment, and negligent homicide. Let's say when someone who under care allows someone else to die. What is suicide? So this is no longer a crime, but you should definitely know it. It's now a mental illness. Kidnapping is unlawful abduction and imprisonment of someone against their will. What is an assault and battery? So assault means simply the type of intimidation that is shown to somebody, whereas battery is the actual physical action thereof.